Hello, this is the last and ninth edition, a segment of the ins and outs of probate for genealogists. This particular edition is called What Happens When the Probate Gets Complicated. Actually, a complicated probate is genealogist's delight. The more disputes there are, the greater the controversy, the longer it drags out, the more information you will get about the family and about the deceased. So long probates, rather than being the traumatic event that in real life, in the life of the individuals involved, for the genealogists, it's a bonanza. So what constitutes a complex probate? Generally, they're caused by disagreements among the heirs, disagreements over who should get what, generally speaking, and they can be caused by the size and the complexity of the estate. It's possible that for very wealthy people that a probate can become an extremely complex matter. It can also become complex because of conflicting claims to the property. This doesn't necessarily have to arise out of any disagreement among the heirs, but there could be third parties, creditors or debtor or other people who may have claims against the property of the estate. And it could also involve property in multiple states or even other countries. So there's there's a lot of different reasons why an estate, probate estate, could become a very complicated matter. Also, to understand that these actions could go on for years. It's not unusual to have them go on for 10 or 15 years. It could go on for even for generations of the family before the matters can be completely resolved. What do we need to look for what may be causing a complex probate? One that can be filed years after the death of the testator or the intestate deceased. So it's if it takes, it could appear even years and years later. There is really no limit to the time that an action could be brought to probate property in an estate that had never been properly resolved or conveyed. Also, you need to watch for time limits in filing a probate. There are some states have variable times in which a probate must be filed after the date of the death. That does not mean that a probate cannot be filed after that time, but there may be some serious consequences to the heirs or to the estate if the probate is not filed within the time period specified by the law. Also, there are time limits that may apply or not apply to certain types of property. Even though there's a time limit for filing a probate, for certain types of property, such as real property, there may not be a time limit. There also may be a time limit imposed on the length of a probate case by the court. These are not necessarily strongly enforced, but in many cases you'll start to see requirements from the court that the matter be resolved. The real issue is how to find a late filed probate. The first place to go look is the real property owned by the deceased. Any record of the transfer to the real property that refers to an administrator or a administration deed or a deed that originates in the estate, executor's deed or administrator's deed, then these particular property transactions indicate that there was a probate case going on at the time. Also, it's important to understand that unless the property was conveyed into a trust, in which case there would be a land and property record of the property being transferred, that after death real property can only be transferred by a court-appointed representative of the estate in a probate action. You might want to watch for joint tenancy, other type of ownerships that transfer after death. If there was a joint tenancy deed that was recorded, or a indication that the person had died, could have been recorded at the time that showing that there was a probate action. So when does a probate case end? Basically on the distribution of all the property in the estate. And the filing of the final notice and for a final accounting and notice of distribution is usually the last or one of the very last documents in the estate file. There is also possibly a court order for the discharge of the administrator, the executor, or the discharge of a bond, if anything. All of these can indicate that the probate case has ended. It's not necessary, however, for any of these orders to have actually been issued or recorded. In many states, there is simply a notice of the final accounting and distribution, and the courts do not hold hearings or do anything further with the probate action. One of the first questions that may come up is, what are jurisdiction and venue? These are court terms that refer to the ability of a certain court to hear a certain type of case. So the legal jurisdiction is the ability of a certain court to hear that case. So in order for there to be a probate action, there has to be a court that is recognized that accepts the probate actions. Venue, on the other hand, is the selection of the proper place or court to file a particular claim or action. There may be jurisdiction in a court, but you may have a different venue. For example, all the county courts in a state may be able to hear the probate actions, but only the county where the deceased died or where the property was located would have the venue to hear the action. So you can't just simply go out and choose whichever court you want to file in within the state. You need to understand that jurisdictions pile up like pancakes. So you have local jurisdictions that go into municipal or state, gradiate to higher jurisdictions. For example, a lower court may have jurisdiction in a county, and then a statewide court may have jurisdiction in the state. Courts of appeal may be statewide, as are Supreme Courts. When does a court have jurisdiction? Well, the court has jurisdiction when it can hear a certain type of case, and that case is properly filed in that court's venue. In other words, the particular court that can hear the action. Again, to go back and repeat from a different standpoint what I just said a moment ago, the general court within a state, for example, in Arizona, they're called superior courts, and there are superior courts in each county in the state. The superior court has jurisdiction to hear a probate action. That's just the way that the law is set up in Arizona. The court that could hear a probate action could be differently named in any other state. As in Utah, for example, they are district courts. And so that's the proper court from jurisdictional standpoint, but if the court does not have the proper venue, then that court may still not have what's called jurisdiction over the case. So if it's not properly filed in the proper county, then the court still does not have jurisdiction to hear the matter. So venue is that there may be different divisions of the court, and if you have venue for the case, then the particular court is the proper place for the action. If the court has venue, it is the proper place for the action. Understand that there are also levels of the court. You have local or municipal courts. You have justice courts or magistrate courts. The lowest courts are usually sometimes called city courts, and justice courts have different designations around the country. They are generally not professional legal people. The judges do not have to be lawyers, and the people who appear do not have to be represented by a lawyer in these lower courts. General trial courts could be called superior courts, circuit courts, courts of common pleas, or district courts. Then there are the appellate courts that hear cases that are decided in the general trial courts on appeal if the parties don't agree with the ruling of the judge in the lower court. And then you have a second level of appellate court, usually referred to as the Supreme Court. And these are state Supreme Courts, although the federal court system in the United States looks similar to this. There are magistrate courts. The general trial courts in the federal system are district courts. The courts of appeal, the district appellate courts or district courts of appeal are and often called circuit courts, are the next level of appeal in the federal system, and then the United States Supreme Court, of course, is the ultimate place where cases can be appealed. Understand that these designations all change from state to state, so you need to know not only know what the courts are called today, but what they may have been called at the time that the ancestor died. Well, what about probates that happen in multiple states? Well, you can look at the record of the real property to see whether or not there are any property transactions that may indicate the property transferred outside of the state. You need to examine any out of the ordinary transactions, something that doesn't seem to make much sense. You need to look for probate documents asking for a stay, or that's a suspension of the case pending resolution of the foreign claim. The word here, foreign, does not apply to outside the country of the United States, simply outside of the court's jurisdiction. What is an ancillary probate? An ancillary probate is held in a state other than the one where the deceased died, and otherwise where jurisdiction lies. For example, if real property is located outside of a state in another state, then it is probably necessary to have a secondary or ancillary probate in the state where the property is located. It's not a complete probate action. It's sort of a cut down or abbreviated action. It has similar pleadings to a regular probate, and attorneys do become involved in these actions, and they usually end up with the transfer of the real property. Now, if there are any probate hearings in the probate case, you need to look for the transcript of any formal hearings. The court may have actually taken down the testimony, and this can be extremely valuable in genealogical research. Also be sure to note the date and place of any evidentiary hearings. Evidentiary hearings may also be reported. Early on, before recording became universal, the courts would make notes or minutes of any hearing, and those may also be in a file. Also watch for affidavits submitted in the support of any claims made. These are sworn documents, testimony usually notarized by a notary public. when you're doing a probate or reviewing a probate case for genealogical purposes, be sure to read everything in the file. Go through the probate file page by page and make sure to record any helpful or pertinent information. I counsel that you do not skim the record. It's very possible, if you do, that you will miss a very important provision and you may come up with a completely wrong impression of what happened as a result of the probate action. It's also important to look for an appeal. Any contested matter, there's always the possibility of an appeal. Well, that wraps up this series. There are 9 videos in this Probate for Genealogists series. They're all on the Brigham Young University YouTube channel, and you may wish to look at the previous segments.